I'm Gordon Vickery, Superintendent of Seattle City Light. City Light has long had a policy of equal employment, practicing no discrimination regarding sex, religion, race, or any other factor. I think, however, in administrating this policy and remaining consistent, it's necessary for each of us to train and continue to inform ourselves on our responsibility. This is the second of 5 training sessions regarding affirmative action and equal employment. And I urge each of you to actively and enthusiastically support and participate in this program. I myself have a personal commitment to the program, and I think that each of us is aware of our own beliefs and commitment to Seattle City Light policy. I again urge each of you to actively and enthusiastically participate in this program.
What is discrimination? A look at current issues in the field of equal employment opportunity and how they affect people who work at Seattle City Light. A panel of City Light employees questions one of the area's experts in equal employment opportunity programs. Our guest is Craig Cole, a former aide with the Washington State Human Rights Commission and member of the Governor's Affirmative Action Committee. Mr. Cole is presently manager of Human Relations for the West Coast Division of a major water transportation firm, and is a member of the Governor's Committee on Employment of the Handicapped. Our panel of City Light questioners is John Holbron, Equal Opportunity Officer, Ken Gorohoff, Employee Relations Manager, Letha Neal, Electrical Helper, and Jim Motz, Electrician Constructor. Mr. Holbron will start the questioning.
Mr. Cole, so that we can all be talking about the same thing, could you please explain what is discrimination in employment?
Discrimination occurs when an employer commits certain negative acts against a person which have been defined in laws and regulations to be illegal. And these laws usually define discrimination to be the influence or the consideration of factors such as race, sex, handicap, and other things in an employment process.
Does this mean that everything an employer considers is potentially discriminatory?
No. An employer can generally do as he or she wishes as long as those factors that we mentioned, race, sex, and a few other things, aren't allowed to influence the process. An employer can look at an individual's qualifications, past references, current work performance. All of these things are legitimate. There are just certain things that an employer is prohibited from utilizing in making an employment decision.
Well, related to City Light, what factors would be discriminatory employment practices?
City Light is under federal, state, and local anti-discrimination laws. Putting all of these together, they don't all say the same thing, but putting them all together, City Light is prohibited from discriminating on the basis of race, color, creed, national origin, age. The age group is 40 to 70 that is protected, sex, marital status, the presence of a physical, sensory, or mental handicap on the basis that someone is a disabled veteran or a Vietnam-era veteran, or on the basis of political ideology or sexual orientation.
That's a mouthful. Is that your list?
No, that's not my list. In all of these factors have been defined by either the Congress, the state legislature, or the city council to be improper employment considerations, and these legislative bodies have declared the influence of these factors in employment to be evils needing to be cured, and they have cured them by banning them from an employment process.
You mentioned there are federal, state, and local anti-bias laws, and they
Correct.
all don't mean the same. Can you elaborate on that?
Yes. The law against discrimination in the state of Washington was first passed in 1949. Later, in 1963 and then in 1964, Congress prohibited discrimination in employment on a national basis. Later, the city of Seattle created its own fair employment ordinances by action of the city council. These laws don't always contain the same language. For example, marital status discrimination is prohibited under laws of the state of Washington. That isn't in the federal laws. In the city of Seattle, the city council has outlawed discrimination based on sexual orientation or political ideology. Those prohibitions do not appear in either the state or federal laws. These differences are completely lawful. The various governmental bodies at the state, local, and federal level are free to provide the kind of protection from discrimination to their citizens that they determine is appropriate.
Craig, how does an employer or an employee know which practices are governed by EEO law, and do they just apply to hiring, firing?
If you take all of the laws together, again, they don't all say exactly the same thing, but taken together, virtually every employment practice is covered by one or more anti-discrimination law. From recruitment to screening, testing, selection, hiring, firing, promotion, compensation, retirement, discipline, all of those things, and anything else you can think of, are covered by anti-discrimination laws. They're very comprehensive.
Well, why do employees always slip up, then face discrimination and think they can get away with it?
You mean employers?
Employers, right?
It's hard to tell why exactly they get into problems where they are committing discrimination or are accused of it. But there are some common situations that arise. One is the old double standard, treating one person one way and a different person a different way, disciplining a person for one thing that another does and gets off scot-free. The double standard is a source of discrimination complaints when the difference in treatment appears to be based on race or sex or religion or one of those things that those factors that we talked about. Another thing that is a major cause of employer problems in the equal opportunity area is the business called stereotyping. Unfortunately, it still occurs, where some employers or some supervisors will look at a person's race or their sex and attempt to make judgments about how they can do a certain job based on their race or their sex. This isn't lawful. A person should be judged according to other non-discriminatory factors.
Then what should an employee be looking for in a person who wants a job or a promotion?
An employer should be looking for things that relate to performance of the job. Looking at a person's references is one thing, looking at a person's qualifications, looking at the individual, that's the most important thing. Don't look at the sex of the individual, that's not really going to tell you much, and it's going to get you into trouble. Look at what can that individual do. What are his or her own individual capabilities and merits?
Well, it's often said that women cannot work in the labor force if it's heavy work. How did this come about?
Conditions of inequality tend to be adopted by custom over a period of time, and there are a lot of sociological and economic reasons as to why people happen to be discriminated against or segregated into certain jobs or out of other jobs. But I think mainly the thing to be concerned about is that an employer should be looking at an individual and as I said, his or her own capabilities. Don't look at the fact, or don't try to guess, that because a person is of a particular sex or race, they can't do the job. It doesn't work, it's not legal.
Doesn't this mean that City Light would have to hire anyone, whether they're qualified or not?
No. There is no law anywhere that says that City Light or any other employer must hire unqualified people, whether they're minorities, women, Caucasians, males, or whatever. The laws simply require that certain factors not be allowed to influence the employment process. Race, sex, religion, national origin, that checklist that we talked about earlier. Those things cannot be in the employment process. Other than that, an employer is fairly free to do as he or she wishes.
Well, it seems like, in all fairness, then, that it's required for employers to hire women and minorities and handicapped and that. What's in it for the rest of the people that are working there?
Well, first of all, EEO laws protect everyone. The laws don't say it's illegal to discriminate against women or minorities. The laws say it's illegal to discriminate on the basis of sex, race, whatever, against anyone. So everybody is protected from discrimination. Minorities and women, the handicapped, tend, however, to encounter discrimination more frequently. I think most people recognize this. That's why you hear about women and minorities exercising their rights under the law. They encounter discrimination more than others. But generally, again, everybody is protected from discrimination. If someone denies me a job because I'm a man and they don't think that men are good at this job, that's discrimination, and I would be able to exercise my rights.
Well, it still seems like a white guy like me is losing his rights.
That is a feeling that some white males have, that their rights are now being infringed upon by equal opportunity and affirmative action programs. In fact, what we are finding, that may happen occasionally, but really what we're seeing most often is a situation where white males have been given perhaps an unfair advantage in employment. Maybe they knew people who controlled who got the jobs. The tests had a bias in them that favored the Caucasian male. When you take that unfair advantage away, that seems like a loss of rights, but it isn't. It isn't. It's the correction of an unfair advantage so that people, in fact, compete equally. It's kind of like in a kingdom where the king for many years only let his own relatives own property, and then one day becomes enlightened and announces that everybody will own property more equitably and some of the land of his relatives will be split up. His relatives are going to feel like they've lost their rights, but in fact they will have lost an unfair advantage to which they really weren't entitled, not to be confused with a right.
Well, doesn't it come down to an individual white male having his opportunities affected by something he didn't have any control over?
I think we're all concerned about now having to pay for the sins of the past. None of us want to do this. Certainly minorities and women do not want, or handicapped people, do not want to continue to incur discrimination or to feel the continuing effects of discriminatory practices. And nobody wants to be, I guess, to feel that they are being adversely affected because these problems are now being corrected. The situation we're in, though, I think most people agree, is that we are now, we just simply have to accept responsibility for what happened in the past, and we have to go through a period of temporary adjustment that is uncomfortable for many of us, but is necessary really to create a better society, the kind of society that we hold America out to be.
Would good intentions of an employer be a defense to accusations of discrimination?
It's too hard to measure good intentions. You can't, or a compliance officer or a court would have a lot of difficulty crawling around in somebody's head all the time to find out whether they intended to discriminate. It can be helpful in a case if an employer meant no harm, but it's difficult to measure. I wouldn't want that to be my only defense if I were an employer. There are many cases where intent isn't relevant.
Well, when would that be?
That would be, for example, where an employment practice places a racial group or a sex of people at a disadvantage. Perhaps people are treated the same, but the end result of the process is that one group or another is placed at in a poorer position in terms of employment opportunities. An example would be where if you were to require that for all secretarial positions a person have a college degree, this practice would screen out a disproportionate number of minorities who are, on the whole, receiving fewer degrees. And it probably couldn't be justified as being a job-related necessity. So that practice would be racially discriminatory because the effect of the practice was unfair, even though perhaps the employer did not intend to be discriminating. The courts and enforcement agencies look at the consequences of an action, not as much to its motives. It's like hitting somebody on the highway, rear-ending them in your car. You may not have meant to rear-end them, but you're probably going to be held liable for the damage.
So, Craig, I guess what you're saying, there's many ways that you can discriminate.
There are essentially two ways. An employer can discriminate by treating people differently. People in the same situation are not treated the same. An example, of course, would be where a male and a female come in to apply for employment. They have the same qualifications. They come in at the same time. The female is given an application and told, you know, we're pleased to receive your application. The male is told there are no jobs today. Well, that would be a difference in treatment, unlawful, discriminatory on the basis of sex in this case. The other way that an employer can discriminate is by perhaps treating everybody the same, but using a practice which, in fact, in the end, places a certain racial group, sexual group, or one of those other protected groups at a disadvantage.
But does this apply to handicap?
Very much so. Take the example of a stroke victim who comes back to work, perhaps requires the use of a wheelchair, but can't get into the building because there are no ramps. If an employer says, sorry, we're treating you the same, we treat you the same as people who can walk, we're giving everybody the same set of stairs to use and the same entrance, that would be discriminatory, because obviously treating people the same may not be treating everyone fairly. In this situation, the employer would have an obligation to provide a way for the person to get in the building so they could work.
In each of these situations, who has to prove their right, the alleged victim of discrimination or the employer?
The burden is always initially on the person who is trying to say that the employer discriminated. It's up to that person to set forth sufficient facts that show that, hey, the employer has probably committed an unlawful practice.
Greg, changing the focus again. City Light has an affirmative action program. Is affirmative action the same as not discriminating?
Affirmative action is related to this phrase that we call equal opportunity or non-discrimination. But they are not the same. Non-discrimination laws tell an employer what should not be done. You will not let race, sex, handicap, marital status, and other things affect your employment decisions. Affirmative action goes beyond merely not discriminating and tells an employer what he or she should do to bring more minorities, women, handicapped, disabled veterans, or Vietnam-era veterans into the employment force. And affirmative action addresses those groups of people which have been historically excluded or not represented in the employment force or in certain occupations. In this case, for example, City Light, the employer is trying to bring more women into non-traditional occupations, bring minorities into types of employment they haven't been into.
Well, then would selective certification, which gives preference to minorities and women, would that be part of an affirmative action program?
It could be. Selective certification, which is the process of giving a certain amount of consideration to a person's race or sex in making employment decisions. That is a process that would normally be used only as a remedy to identifiable discriminatory practices. Normally it wouldn't occur in the absence of a finding by an employer, such as the City of Seattle, who has found that things haven't been fair. We now must make an attempt to adjust that or to make up for that unfairness. An example of this would be mini tests. Although we all kind of hold tests out, I think, to be the ultimate merit device for determining who ought to be employed, mini tests are not fair. And they cannot always be justified as being job-related and actually helping the employer choose the best employee. Well, where these tests cannot be shown to be job-related, and they would place minorities or women at a disadvantage because they tend to score lower, have lower passing rates, or whatever, this practice would be discriminatory. What's the employer going to do? Well, the employer should probably adjust that test to make up for the unfair advantage that it gives to others. Again, this isn't common, but it does occur, and it is used in, for example, the City of Seattle, where the employer voluntarily has decided, hey, we're going to do something about this.
Yeah, but how do you deal with the argument then that people often come up with, that these kinds of affirmative action techniques constitute reverse discrimination?
The employer is in a pickle because if the employer does nothing and allows a practice to continue discriminating or placing people in an unfair advantage. The employer winds up violating...
Do you mean excluding people?
Yes, in many cases, it appears that the employer is providing special or preferential treatment to minorities or women, when in fact the employer is simply trying to remove unfair disadvantages that are now built into the employment process. So that's usually how selective certification is used. That's how it's used in the city of Seattle.
But won't this mean that women will be taking the good jobs for men?
No sex of people or no race of people can put a claim on occupations. Everybody has to be allowed to compete for a job on the basis of individual capabilities. So women, yes, women will be in the running, but no, women won't be taking away jobs that belong to men, because nobody can claim ownership to an entire occupation.
But what if women can't do the job and the men have to do it for them?
Well, if a woman can't do the job, and she's being judged fairly, assuming she's judged by the same standards that everyone else is, and they're job-related standards, and the woman can't do the job, she can be dealt with in whatever disciplinary manner people are normally dealt with. You can fire the person if they can't do the job, or you can suspend them or reprimand them or whatever the normal personnel process is. If you can't do the job, you don't have a claim to it. It doesn't matter whether you're a woman or a minority or who you are.
Well, as far as affirmative action is concerned, then what's in it for the white male?
I think that most people in personnel realize now that by requiring employers through affirmative action programs to treat minorities and women more equitably, that the process has become more fair for everyone. Now everybody must be treated fairly. Arbitrary actions that an employer used to be able to take now won't fly very well under personnel procedures that have been adopted as a result of affirmative action. So there's a great spin-off effect on an awful lot of people. Generally, employment procedures are now more fair for everybody. The other thing is that affirmative action itself targets an awful lot of groups. When you, if you want to just count numbers, you add in veterans, Vietnam-era veterans, disabled veterans, handicapped people, minorities, and women. You're taking in a great cross-section of the society just in those groups that are the specific targets of affirmative action at this time.
Going to something else for just a second. Affirmative action has recently been targeted for handicapped. And as employers, what we're being told is that we must give reasonable accommodation. What is reasonable accommodation?
The best way to describe it would be to give an example using the stroke victim case. A reasonable accommodation would be to provide a wheelchair ramp for someone so that they could gain access to the building in which they are to work. In other cases, it might be installing an amplification device in the telephone so that a person with a hearing impairment would be able to use the telephone, or to provide a certain device for blind people so that they are able to determine which line on the telephone is ringing. These are examples of reasonable accommodation, doing things that make employment opportunities possible, short of creating an undue hardship on the employer.
Yeah.
But there are times, though, on this reasonable handicap question, there are times that the city is faced with a real bind, in that people come up with what's termed the handicap, as an example, in the city with back problems. And it's a big problem in the city, and it's a big problem in City Light. Somebody has a back problem, either existing without their knowledge before they came here and they find out about it through a medical evaluation, or comes as a matter of course and part of their job. What do you do with that kind of person who appears to be physically able to do the job, but somebody says you have a physical problem that could stop you from doing that job?
Well, few of us are qualified to determine whether a person is capable or incapable because of a handicap to do a job. So in these situations, the employer should first determine, with competent medical advice where necessary, whether the type of handicap involved would interfere with performance of the job. If the person is going to be working in a capacity that involves little heavy labor, perhaps the back problem won't interfere with the job. If it would, the employer should look at the individual's condition, have a doctor, the individual's physician, a consulting physician, check the person out. Hey, is that back problem likely to be an interference with job performance, or is it likely to be aggravated on the job? What's your medical judgment? And if those answers come up, no, it doesn't look like it's going to interfere, or if the employer finds that, say, it would interfere, except that there is an accommodation we can make here. We can give assistance in there's somebody on the crew that can help lift those heavy things once a day. If those answers come up in the employee's favor, the employer should not deny that person an opportunity. Because, again, getting back to the question of job relatedness, we're determining that those things would deny a person an employment opportunity, but cannot be tied to some kind of legitimate business necessity.
Well, also this concept of reasonable accommodation is in such things as religious observances.
Yes, there are two areas where reasonable accommodation applies. In the area of handicap discrimination, which we outlined, also in the area of religious observances. An employer must attempt to accommodate an individual who has to, whose religious convictions, for example, would prohibit him or her from working on certain days. The employer should attempt to rearrange a schedule to allow that person to continue those religious observances. Again, short of an undue hardship.
On the question of reasonable accommodation, oftentimes a point is made regarding either a religious observance or a person who has to be a reasonable accommodation for a person who may have a handicap, that the argument is made, we need people here all the time. We need a full-time worker. We need a worker who's well. I can't be having people off my workforce. I need them there all the time. They got to be well. Now, how do you deal with that kind of a person who keeps coming at you and says, I want that person here all the time, and I want him well, I want him healthy?
Well, nobody's perfect. Humans are humans. They're going to have imperfections. If you cannot get the job done by accommodating an individual because of their handicap or because of their religious observances. Now, we're not talking about giving a person a day off whenever they want it, or not making them do their work. We're talking about really relatively minor things, adjustments in their job or in their surroundings, which enable them to get the job done. We're not talking about letting people report for a paycheck and not doing their work. Again, the concept of undue hardship. If the employer can't get the job done by accommodating individuals or going to the degree of accommodation that the individual requests, it's not required by the law.
Well, as an employee, what obligations do I have under these EEO laws?
First, if you're a supervisor, it means that you should be fair. The most important thing, I guess, is to follow 3 steps. Think before you act. Think through the consequences of an action that you're going to take with respect to an employee, whether it's hiring them, disciplining them, firing them, whatever. And think it through first. Don't act without knowing what you're doing. Secondly, base your decision on job-related criteria. Don't hire somebody for an electrical draftsperson's job because the person has a PhD in music. These kinds of arbitrary things or improper considerations can get you into trouble. So be job-related in what you're doing. Thirdly, treat people the same. Make sure you're treating people consistently, judging them by the same standard. Follow those 3 steps, and most EEO problems vanish. And if you're a supervisor, you'll also be treating people fairly, which is probably the most important point. Okay, now if you're an employee, the first obligation is to yourself. Learn about these programs to see how they can benefit you. They are there for you. So find out about them, see what's in it for you, how the program can be used to your advantage. Secondly, as an employee, you have an obligation to treat other employees, co-workers, with dignity. Refrain from racial harassment or abuse, sexual harassment or abuse. Those things which are improper, really, on the job, poor conduct, and which also interfere with the realization of equal employment opportunity. Thirdly, as an employee, I think all of us, as citizens, responsible citizens, have an obligation to support public efforts which are aimed at making America, I guess, reach its ideals, the ideal of equality and freedom for everybody. And I think we should all contribute to that, because that's what makes America, I guess, what we all would like to see it be.
Craig, thanks very much for sharing your views with us at City Light.
Thank you.
I appreciate that.